I am John Tansky. I'm Vice President and Associate General Counsel at Tyson Foods. I'm also a member of the Executive Committee of the Antitrust and Consumer Protection Practice Group here at the Federalist Society, which is sponsoring this panel. And that's how I have the honor of introducing the panel and our moderator. If you're interested in getting more involved with the Federalist Society practice groups, please reach out to Nathan Kazmarek. He's the one who introduced our first showcase panel this morning. He's in charge of practice groups, and he'd love to hear from you. So our title here is The States and the Future of Fair Competition, and it's interesting to me, we had a panel yesterday about Delaware versus Texas, and that was states competing with each other. Here, I think what we're going to hear about is more states cooperating both with one another and with the federal government to try to co-regulate competition in the United States. Now, if I were Dean Reuter, that would remind me of a story. But I'm not Dean, so I don't have a story, and we're already starting a little bit late. So I'm just going to go directly to introducing our moderator, Judge Stephen Menashi of the United States Court of Appeals for the Second Circuit. Judge Menashi has a very impressive background, which I'll try to summarize briefly. He was nominated by President Trump on September 9th of 2019, confirmed on November 11th of 2019, so happy almost anniversary, Judge Menashi. Before he became a judge, he was special assistant and then associate counsel to the president. He was acting general counsel of the U.S. Department of Education. He served as an assistant professor at the Antonin Scalia Law School at George Mason University, where he taught administrative law and civil procedure. He was also a research fellow at NYU Law School and Georgetown. Before that, he was a partner at Kirkland & Ellis in New York, where he practiced appellate and commercial litigation. He clerked for Judge Douglas Ginsburg and Justice Samuel Alito. I don't know how you had time to do all of those things. He's a graduate of Dartmouth College and of Stanford Law School. I did notice that your bio was missing one important accomplishment. You actually presided over the last appellate argument I had in private practice before I joined Tyson, so you might want to add that. But thank you. I'm going to turn it over to Judge Menashi.
Thanks very much, John. I'm delighted to be here. Welcome to the antitrust panel. You might have noticed originally this was going to be about federal antitrust enforcement, but because of the shutdown, we decided to hear from parts of our government that are still open for business. So today we're going to hear from two state attorneys general about antitrust and consumer protection priorities in the states and how that works. So I'm going to introduce both of them, and they're going to give some opening remarks, and I'll ask some questions, and then maybe you all will have questions of your own. So first we're going to hear from Jonathan Skrmetti. He was sworn into an 8-year term as Tennessee's Attorney General and reporter in September 2022. Prior to that, he served as Chief Counsel to Governor Bill Lee and as Chief Deputy Attorney General to Attorney General Herbert Slattery. Before that, he was a partner at Butler, Snow in Memphis and worked as a federal prosecutor at the Civil Rights Division at DOJ and at the Memphis U.S. Attorney's Office. He graduated from George Washington University, University of Oxford, and Harvard Law School, and was a clerk on the 8th Circuit. Then we'll hear from Attorney General Yost of Ohio. He was reelected as Ohio's 51st Attorney General in November 2022, receiving more votes than any other Attorney General in the state's history. He says his goal is to do big good for the people of Ohio by protecting consumers, rooting out corruption, defending the environment, ensuring an open and competitive marketplace, and fulfilling the duties of the Ohio Attorney General's office. He began his career in public service as Delaware County Auditor and then the Delaware County Prosecutor. From 2011 through 2018, he was Ohio's Auditor of State, and in January 2019 began his first term as Attorney General, and he has degrees from the Ohio State University and Capital University School of Law. So with that, let's begin with Attorney General Skrmetti.
Thank you, Judge. I want to start by talking about administrative law, and bear with me because this is relevant. So administrative law is really important to me because the core evil that our country was founded to avoid was the concentration of power. Our founders looked at human nature. They realized that if people had unchecked power, they were very prone to abuse it. and they created a governmental structure that was designed to limit the opportunity any one of us had to abuse that authority by creating checks and balances, accountability to the people, a system that kept itself functional and that improved life for everybody involved as a result. If you look at antitrust law, some of the same principles at a high level apply. The concern is with the concentration of power with no accountability. In a functional market, the participants in the market are held accountable by the people, but there are times when markets get broken, sometimes deliberately, and the consumers no longer benefit from the market. It is designed to allow powerful entities with no accountability the opportunity to abuse their power to the fullest extent that they can get away with, and that's a problem. We need markets to function to benefit people, just like we need governments to function to benefit people. And when you're looking at either powerful governmental interests or powerful corporate interests that are benefiting at the expense of the people they are supposed to serve with no mechanism for accountability that works, that is a problem that undermines the legitimacy of the overall system. And so in antitrust, it is the government's role, whether you're talking about the federal government or the state government, to create accountability where the market has broken down. And that is for the benefit of consumers. I'm sure we'll talk more about the nuance of that going in, but the principle is really important. We need to defend markets from collusive behavior or from exploitive monopolists, not because we don't like big business, but because we love capitalism and we want it to work. Capitalism is good because people who participate as consumers are better off for a system that relies on relentless competition to give them the best quality at the lowest price. And so when we look at antitrust cases, the idea is not that's a big company and they're bad. The idea is we want to make sure that consumers are benefiting from this great system and that we're not seeing it rot from the inside. So there is a substantial state role to play in antitrust enforcement. Everybody knows that Standard Oil really kicked into high gear federal antitrust practice. It also kicked into high gear state antitrust practice. And it was the first instance where the state AGs really came together to work across party lines, to work across state lines, to pool resources to deal with an entity that was radically larger than any one state could compete with. And that created a model that has existed in one form or another to this day of the multi-state enforcement activities. Happens in consumer protection, but it was birthed in the antitrust context. And the state AGs for a long time have been the primary champions of consumers in our system. The FTC has a role, the DOJ has a role, but the AGs have been the most consumer-oriented entity in the spectrum of the federal system and American government for over a century. And we continue to play a big role there. And as the federal government's engagement and resources ebb and flow, the states have the flexibility to step in, and we're in an era where I think you're seeing a lot more state antitrust enforcement. You're seeing more antitrust enforcement in general. In part, I think that's because we're seeing much more consolidation for a variety of reasons in some very big, very important markets. In part, it's because of developments in antitrust law and questioning some of the orthodoxy of the last half century. And I think there's a harmonious way to look at what's going on now as part of an unbroken development. But whatever the reason, if you're a law student, take antitrust. There's a lot going on there. And I would be remiss not to say we are hiring. If anybody's interested in enforcing antitrust laws or other state laws, we have opportunities for you in Tennessee. Thanks, Judge. General Yost.
Could I just do a sort of a quick follow-up before we do the other? So you began by talking about how part of the concern is unchecked power, and that kind of plays into a debate that's going on in antitrust about the status of the consumer welfare standard or whether antitrust has broader purposes. But you also said it's not just because we don't like big businesses. So how do you think about that? Is the mission to protect consumers from higher prices and reduced output, or is there a broader mission where there are other effects of corporate consolidation that you're worried about for society?
So there are broader effects that I'm worried about. For instance, in technology, when you had a thin monoculture on the West Coast that controlled the information flow across the country, that had impact on our republic's functioning, right? Like, it affects elections, it affects people's ability to hold government accountable, their ability to operationalize their individual concerns. And done wrong, it can alienate people from government. But I think there has to be some sort of objective standard to restrain the inverse impulse on the other side of government to get too powerful. So there has to be some sort of doctrinal constraint to keep us from just using this very powerful set of antitrust tools because we don't like somebody's politics or religion or race or whatever. There has to be something that we can measure. And the example that and I'm going to get in so much trouble for saying this, but the example that I think of is SpaceX. SpaceX has a functional monopoly because nobody else is able to put as much into orbit as they are. But they've been very careful not to leverage that monopoly to advantage their other businesses, or at least that's, to the extent that I am informed, it appears that they are being very cautious about that. So if somebody wants to compete with Starlink, for instance, and have their own satellite constellation for communications purposes, SpaceX is saying, we will charge you the same rates, go ahead, put your stuff in orbit, we welcome competition. It is not SpaceX's fault that nobody else is able to effectively compete in putting stuff into orbit. I mean, at some point there will be more competition on that front. For now, they're way out front. Good for them, that's benefiting everybody. It would be a wretched violation of the principles of government to hammer them for being successful at what they do. But if they started to leverage the ability to put things into orbit to disadvantage competitors in other spheres where there is competition, that would hurt consumers and would reflect the kind of monopolistic behavior that we should be concerned about. So I think we need to look at antitrust from a broader perspective, but I think we should only enforce it within a clearly defined lane so that everybody knows what they're supposed to do going forward.
Okay, thanks very much. Attorney General Yost.
Thank you, Judge, and I would agree with a lot of what Jonathan said. I would start, though, with the same place he did, which is power. And a part of the problem with our current body of antitrust law is that it is so anchored to the consumer welfare standard that it ignores other public goods. And that's an artifact, essentially, of when the organic law was passed. Our law, the statutory law, very broad, 130 years old almost. And the economy of the late 19th, early 20th century is vastly different, not just in scale, but also in kind. So I'm kind of critical of the consumer welfare standard as being the sine qua non of when the government may exercise its power as a counterbalance. The danger, of course, is that the government itself accrues to its own hand a level of power in the economy that is antithetical to free markets and competition and prosperity. Mark Twain once quipped that when buying and selling is sold, the first thing to be bought and sold is congressmen. I think that it's past time for us to jettison a great deal of the judge-made law regarding antitrust and go back to first principles and ask, what is the essential problem with antitrust in the 21st century in an information economy that's bordering on an AI economy? Let me give you a couple quick examples. One is the question of who is the consumer? If we take a look at an obvious case of Facebook, we might think that all of us that are on Facebook are the consumers, and that we're consuming social media services, that we're connecting with our friends and getting cute videos about cats and spying on our children, to the extent that our children are actually on Facebook and not on Snapchat. The problem is that's not really the business model. We're actually the users of the product, not the consumers, and the advertisers that buy ads are actually the marketplace, arguably, in Facebook. And yet we who use it might look at this situation. How would you measure the consumer welfare for the users of Facebook? There's no price to it, so it can't be price. The shoddiness of the product is pretty difficult to quantify, and the question of the availability of the resources, it's kind of almost infinite, right? I mean, nobody gets told you can't make another post because you've done too many today. So I think that there's a whole host of problems that we can't think about very well in an era where economics has become very entangled, where we have multi-sided markets, which leads us to a secondary problem with this consumer welfare standard, which is that it doesn't account for things that are not bought and sold, or not directly bought and sold in that particular market. Think, for example, about intellectual capital. We, in the healthcare industry, have seen a great deal of vertical integration. It is sucking intellectual capital out of smaller communities and medical talent in a way that it may indeed drive prices down, although there's some interesting mixing in the evidence about that. But it certainly drives down the quality of life in those underserved communities. And yet antitrust, which is supposed to deal with the accretion of power in private hands for the public interest, it really has no answer for it. I could go on with several other problems that we've grappled with, but in the interest of a broader discussion, I'm going to kind of draw a line there and conclude by saying I believe that the time is right for us to do a top-to-bottom rethinking of antitrust law. How do we protect against government excess and favoritism in the marketplace and yet still prevent oligarchy or control or oligarchical tendencies and their impacts on the marketplace and the general public? Because there's also an argument that certain contexts that an oligarchic function is not entirely malign.
Well, thanks. I mean, that was interesting. In antitrust, Robert Bork famously suggested that the reason for the consumer welfare standard was because it was the standard that was consistent most with rule of law principles, that you could have a standard that's administrable and that could lead to predictable results. You're suggesting maybe it's not as administrable in the current economy. And you said something about going back to first principles. How would we start a discussion about what those principles are if it's not the consumer welfare standard?
So I would suggest that we start by identifying public goods. We had a set of public goods in the Sherman Antitrust Act that were in mind, which is avoiding the restraints on competition and promoting a free marketplace that would actually promote economic growth and innovation. That was the idea. My suggestion is that in the 21st century, we have additional economic or public goods that we should be protecting through antitrust. And I suppose if we opened it up for comments, we might quickly develop 8 or a dozen here today. I've mentioned a couple. The other thing I would suggest is that we need to think about our structure of response, our remedies, because the remedies that we have are either minuscule or draconian. And we don't have to have this kind of statist response. For example, let me offer this just as an idea, and I'll be the first to admit that it's not entirely fleshed out and subject to plenty of criticism. But what if we structured our system so that we focused in the states on smaller, localized restraints of trade, abuses of non-competes, for example, or vertical integration of a local supply chain that inured to the detriment of the economy. And for the very large stuff, which is really expensive, really slow, really hard to do, what if we had a two-part thing where instead of walking into court and saying, Google's a monopoly, they're restraining trade, and we want them broken up, and so we fight for years and years and years over that. What if instead we had the ability for a public actor to go to court and say, Judge, we think that Google is acting in and we'll call it oligarchical, but some kind of dominant fashion, and we just want a deck judgment. And that there's a set of rules that apply if you get that big and that dominant. There's certain things you're not allowed to do in predatory acquisitions, for example, of new products. There's certain things that you're restrained from doing that would otherwise be acceptable. That declaration would be a much easier rifle shot kind of litigation. If you win it, then the company is on notice that they're under this more stringent, heightened set of rules, and they get to adapt to that, not unlike energy utilities in regulated situations. There are things that they're not allowed to do, or publicly traded companies. Once you enter the world of the SEC, your freedom is greatly constrained because of your size and the impact on public trading. I'm not saying that that's the answer. I'm just throwing that out there as a way to challenge all of us to think about what could this system look like if we were building it for the first time in 2026 instead of inheriting the Brandeisian statist overreach and all the development of that, and then the reaction for the Chicago school and Judge Bork's work, and ended up in this amazing morass of law that we have today.
So can I ask, when you talk about imagining it from the ground up, do you envision a kind of legislative reform where like a different statutory framework, or you think this is something we should do within the existing antitrust laws?
Oh, I think very much it needs new statutes. I don't see any way to do this through litigation, and wouldn't approve of that. This is a major question that belongs to the Congress.
Do you have thoughts about this expanded role of antitrust?
I mean, I do worry about government meddling too much in industry. One of the most egregious violations of sort of the state's authority in recent memory was the pressure put on the social media companies by the government to censor. And I think if there's unbounded or less bounded governmental authority over big entities without really, really clear rules, then that creates more opportunity for government to leverage its authority as a regulator over these very big, very powerful entities in a way that's corrosive of liberty. So I would be nervous about throwing open the floodgates potentially to a broader antitrust authority. I think we have other tools as well. So there are a lot of consumer protection tools that are often able to remedy things that at first glance look like they might be antitrust violations. I think having some sort of clear objective standard is important. And I think with multi-sided markets, you can look at consumer welfare in terms not just of pure cost, but also, you can find ways to at least articulate declines in quality, declines in privacy. Makin Delrahim had a lot to say about modernizing consumer welfare. What you don't want is to have your Nobel Prize winning economist and the other side's Nobel Prize winning economist write impenetrable documents. I mean, if we could do that math, we wouldn't have gone to law school, right? And They throw them at each other, and some poor district court judge is sitting there with a look of absolute horror, thinking, this is my docket for the next 5 years, trying to figure out how to work through this. I mean, antitrust cases were brought before the math got really complicated. There's a narrative approach where you can clearly say, pointing to evidence, this is an antitrust problem, without necessarily having to resort to the extreme quantification that happens a lot these days. And again, I do worry about creating an unbounded governmental authority, but I think you could hold the government to its burden without requiring that burden to be a new set of Nobel Prize winning documents that 4 people in the world will understand.
Well, just a quick response. I started out by talking about how the government's response to authority could be its own problem, and I completely agree with that. I've spent my entire career fighting against the expansion of government and the abuse of government authority. So I completely agree with you on that. That doesn't mean that the economy has not changed, that there are not public goods that are affected by combinations and agreements against competition that are worthy of recognition. So agree with you, objective standard. I agree with you on important controls on the exercise of government power. But I do think that there are major issues still in our economy that have risen in the last 50 years that ought to be addressed.
It sounds like one of the issues in that discussion is agreement on the possibility of abuse of government power, and then the extent to which you might be concerned similarly about consolidated corporate power, and whether that's on par with the threat from government power or it is a lesser concern. Is that fair? Does that seem to be like, to the extent that there was a disagreement here?
I mean, I think it's fair. I mean, I think the ultimate fear is consolidated government power and consolidated corporate power working hand in hand, which is what we saw hints of in the tech sector under the Biden administration. A terrifying future if things move in that direction. And as you see, because of the infrastructural demands, you're seeing a pretty concentrated AI industry right now, right? Like the huge data centers involve massive outlays of resources. And so there are only a few companies that can realistically participate in that. These are potentially the most powerful companies in the history of the world. I mean, they already are, right? Like Google is, I've seen an analogy, the closest we've ever had to Google in human history in terms of the power of a non-governmental entity is the pre-Reformation church. These companies have unbelievable amounts of power over everybody's day-to-day life, and they're probably only going to get more of that as the technology advances. And government needs to hold them accountable. But if we get into a situation where the oligarchs are running both sides of things, that is the gravest threat to liberty we may have ever seen as a people, ever. So, I think we need to look out for concentration on either end, and we also need to make sure there's a bright line so that one side is not able to leverage the power of the other at the expense of the people on the receiving end.
I agree with that, but I would suggest that it's a very context-specific kind of determination. And General Skrmetti's, I should give some kudos to your work in the tech industry and the censorship that was occurring during the COVID era. You led the country and brought to light a number of important facts that are informing that otherwise never would have been known, that are informing the debate today. So congratulations on that important work. However, there are times that the private sector has the ability to have a greater impact. Now, than the government. I don't think that that's in every case, but your comment about Google's more important than any private organization since the pre-Reformation church is kind of on point. In a particular context or in a particular market, we now have companies that have a level of scale that was only achievable by a government very recently in history. They have a capacity for action that would have taken a government and armed force in the past. So I think that both are extremely dangerous, in combination, as General Skrmetti said, they are terrifying, and we need to return to the founders' wisdom and separating powers and causing them to jealously guard their own spheres as a bulwark for our own freedom.
Great. Could I ask a question about sort of the role of state enforcement vis-a-vis the federal government and maybe between states, right? So one concern about state antitrust enforcement might be that states could use that authority to kind of protect an incumbent local industry at the expense of a national competitor that's come in on the pretense that that national competitor is operating within the state, but really it's a kind of protective thing. Another concern might be that a lot of state enforcement might mean that companies have to comply with 51 different regulators, and it ends up being duplicative and overly burdensome. So how do you address those concerns, and when do you decide to work with, and do you ever work against the federal government? Maybe you each could address those basket of concerns.
So we were against the federal government during the Biden administration. There was an action brought to prevent the combination of the merger of Albertsons and Kroger, and we felt that the evidence was insufficient to support the contention that it was anti-competitive. So we wrote a brief on the other side in that case. The bigger question is, antitrust is so massively expensive to do, both in time and money. Under my predecessors, we joined, because Ohio is a pretty big state, we joined a lot of multi-state actions. About my third year, I realized that I was being asked to approve actions that had only a tenuous connection to Ohio's specific interest, and they were much more a national interest. There's certainly moments for the states to band together, as they did in the Standard Oil case. But I've given direction to my team, my antitrust team, to give preference to matters that are not only Ohio specific, but tethered to place. So if you think about it, there are certain things that can easily go to Mexico or Florida. There are other things that cannot. An example is healthcare. And yet we see, massive vertical integration and consolidation in the healthcare industry. I alluded to this when I opened my comments. But there is an interest in local communities to be able to maintain local medical service and not have to drive 100 miles to get treatment. Hospitals are not going to move. They can close, but they don't move. And there's a competing value there. You can't cause something that's losing money to, by force of government edict, stay open. But I think that we ought to think about healthcare, as an example, as something that has a priority for state antitrust regulators. Another one would be farming. Agriculture is very much tied to a particular place. We're not moving any of the farm fields from Western Ohio to Nebraska anytime soon, and without an act of Congress. But I think that to answer your question, it's important for us to begin to think about a federal lane of national or global concerns, and to recognize that in many of our states we have individualized important concerns that nobody else is going to deal with unless the state attorneys general
and so
pay attention to it.
What characterizes the examples you give of the healthcare and the farming is that you're talking about competition within the state, and the federal government is not going to particularly pay attention to whether a particular community in Ohio has competitive access to healthcare. Okay, Treasury General Skrmetti.
Well, first, in response to the concern that you'll have, that there are 56 AGs between the states and the territories, and the idea that you'd have 56 regimes could be a big problem, except for the resource constraints. So maybe New York and California can go it alone on some of these big antitrust cases, but I don't think any of the rest of us can without substantial outside help. And generally, it's not realistic for us to do that. So I think empirically, you can see that this has not been a real concern to date, at least as far as I'm aware. There are a lot of times where, because the focus is on consumers, we're looking at what's happening to our consumers, and they're dealing with the same problems generally that are happening in other states, and the federal enforcement entities are looking at the same problems. So there's been a lot of collaboration between the states acting to some extent collectively and the federal government. There are occasionally cases where there's a harm that is strictly in state, and we have acted alone, but that's relatively uncommon in the antitrust context. Healthcare is interesting because it's so heavily regulated, and we actually have a COPA, we have a legally authorized monopoly in part of Tennessee on healthcare as an effort to deal with some of the significant issues that hit rural healthcare based in large part on these very broad federal regulations. And I think there is certainly in healthcare, and especially in health adjacent industries, a lot of concern about anti-competitive behavior harming consumers a great deal. But the regulatory layer makes it particularly challenging because there are sometimes federal entities that are affirmatively creating problems that make it hard to solve the competition issues. So, I don't think the idea of states going crazy and over-enforcing the antitrust laws is realistic in the near term, just because of the amount of effort that goes into making one of these cases.
And you mentioned that the states and the federal government often bring the actions together in a kind of cooperative coalition. How do you decide when you want to do that, and does the state participation in that make a difference? Do you raise particular state concerns, or are you just you're sort of standing for the same principle?
It really depends. I mean, there are times when the states play a very significant role. There are times when state laws allow potential remedies that aren't available under federal law. There are times when the states contribute a lot in terms of resources. Again, the federal government has resource constraints too, and so there are times when they rely on the states to provide lawyers for the trial team, provide help with discovery. We can bring in outside counsel sometimes in ways that the federal government can't, and so there are opportunities there. So it's case by case the extent to which states are involved. Sometimes we jump on for the ride, and it's a way of further legitimating the federal action, but we really don't have a lot of operational input. Sometimes we're very engaged. In the Google search trial, we had 2 people from my office on the trial team. Colorado had some folks on the trial team. I think some other states did as well, and that's not uncommon. There are some cases where it's a smaller group of states. In the RealPage litigation, which is this algorithmic case where a company was aggregating supply and price information for commercial real estate, you had a few states that identified markets within the states where there were impacts on the consumers. I mean, where rents were rising because of allegedly the activity of this aggregating company. And so we jumped in with the federal government on that for 2 reasons. The first is it's a real harm. It affects consumers in a bad way. The other reason is because we're going to see more and more of this algorithmic stuff, and it's important that the law be clear. At the end of the day, the single most important thing that the law can be is clear. And we want to give clarity so that innovators know where they can innovate and where they're going to get everybody indicted if they keep going in that direction. And sometimes the best way to do that, especially given a Congress that isn't feeling particularly legislative these days, is to draw lines through litigation. So we have a couple of these algorithmic cases where it was initiated by DOJ, but with a lot of input from some of the states, and we are working through it together. And then in some of the cases, some of the tech cases in particular, you're seeing extreme collaboration where it's, when you go up against one of these tech companies, you're not up against an army of lawyers, you're up against an army of law firms, and their resources dwarf most countries, literally. So it's really an all-hands-on-deck situation.
You have thoughts about state-federal partnerships?
Yeah, obviously we partner with the federal government on a case-by-case basis, frequently do. We continue to. Had a conversation this morning about a case. The real estate algorithm case that you just talked about, Ohio didn't get in first on that because it's not as widely adopted in our state. So we looked at the data and made a tactical decision that we weren't going to join that particular action at the time, but we're monitoring it and looking at, and if the discovery ends up developing things that implicate Ohio's interests, we'll either be adjacent to it or join that action. And I think a lot of attorneys general are having to pick their battles these days by how tethered it is to their state.
We were talking before the presentation about the NCAA litigation, but it hasn't come up in the conversation, so maybe you want to talk about that for the group.
So Dave has his own NCAA litigation that we participated in with some other states, and then we had a case. So name, image, and likeness is an intellectual property right that student athletes have. The Supreme Court recognized that in Alston. The NCAA had rules that were not enforced about limits on name, image, and likeness compensation. Charlie Baker, the head of the NCAA, talked about how it was the Wild West. No one was enforcing these rules. There are no rules. 2 months later, they had identified a number of significant programs, and they were going to enforce the heck out of these rules with extraordinarily severe penalties potentially coming into play. And college football is super important in Tennessee.
It is as important as it is in Ohio.
It's a very important thing in many places. It's also a huge piece of the East Tennessee economy. I mean, UT football brings in something like $500 million a year in economic activity. So it's not just we like the football team. We do like the football team. But, I mean, there are real consequences to the arbitrary enforcement by a giant cartel that has not been held accountable by anybody effectively in many years. And so we moved. Usually it takes a long time to put together an antitrust case. We did not have a long time, and so I had an incredible team of lawyers. Cam Norris, who was on the panel yesterday, jumped in as outside counsel. We had some great internal work from my consumer protection team, and we sued the NCAA. Virginia jumped in, I think in part because James Madison University had been on the receiving end of some really bad conduct by the NCAA recently, and we sued saying you're violating the Sherman Act. We did not get the TRO, but we added a little bit more evidence, and we got the preliminary injunction. It was my fervent hope that this would be one of those scope of relief issues where only the litigating states were entitled to the relief, and that would have been popular in Tennessee. But alas, the NCAA does care about competition, and they said if we can't enforce these rules in Tennessee, we're not going to enforce them anywhere. And so the NIL rules that they had. That were a problem because they limited the ability of the student athletes to explore the market. They said, if you're a student athlete, you cannot negotiate NIL compensation until you've committed to a school. Well, what kind of a negotiation is that? You're locked in. If you're not able to explore what the different options look like before you make your decision, it's a completely meaningless negotiation. So I thought it was not that hard an antitrust case to make, and ultimately the court agreed.
Can I get an amen?
Okay, I have some more questions, but if anybody in the audience has them, why don't you line up at where do we have? Oh, the microphones are on either end of well, I see one there, but I don't know where the other one is. But while we're waiting for people to line up, let me just ask this question, which is, on the federal level, we're having a debate about whether the president can fire commissioners of the FTC. Question about whether, the FTC, the antitrust enforcement is better if it's independent from elected officials. I guess the question is, you're both elected officials, so is it better for the antitrust enforcement to be under the control of politically accountable officials, or do you benefit from expertise that's more insulated?
So I'm actually appointed by our Supreme Court, so I'm
fine.
Substantially less legitimate than Dave is.
Well, maybe that's, yeah.
As an aside, Humphrey's executor was wrong when it was decided, and it continues to be wrong to the extent it still exists. But thank you. If I can't say that at a Federalist Society conference, something's wrong with the world. I think there has to be accountability one way or another in enforcement. AGs have a tremendous amount of discretion in enforcement authority, but we need to make sure that there are policies consistent with what our lawmakers have authorized. And I think there are not a lot of external constraints on us. I mean, every AG, with a few exceptions, is independent. I answer to, I don't want to say I answer to nobody, but I mean, unless I'm impeached, there's nobody who can directly tell me what to do. The voters authorized Dave to make big, important decisions about a variety of things, including consumer protection and antitrust. But there has to be, for the sake of prosperity, there have to be bright lines. And so I think we can't stray too far away from the heartland of what the law authorizes without risking the legitimacy of what we do.
Yeah, so there's two separate questions there. One is it better for something like the Federal Trade Commission to be independent? And that's a policy choice that was actually made a long time ago by the founders when they created a unitary executive. Now, we could argue about whether that's a good idea or not, and there's a way to fix that if we conclude it's bad. We can go create an amendment that will allow an independent commission to exercise that authority. Absent that, the second question is it constitutional? And the Constitution is pretty unambiguous. About the only thing really to argue is whether a function is actually executive or judicial or legislative. And there's some argument that there are legislative and judicial functions at the FTC. I don't personally buy them, and I think the president has the authority to remove those commissioners for no cause at all. And I think the president is accountable to the voters if he misuses that power. But yeah, I think that this whole superstructure that we have of unelected, independent, very important and powerful bureaucrats is about to come crashing down.
I do want to add, though, I think within the scope of the unitary executive, and if we had a more functional federal government, I mean, the polarization has really hurt things, but assume that we go back to the older days and there's a little bit more room for bipartisanship. There are prudential reasons to give a platform to people with differing opinions, provided they're not in the majority making the decision. So I do see value in having minority representation potentially on some of these commissions. They're still subject to the president, but competition benefits the end users, and having competition in what ideas are being operationalized by these agencies, it potentially helps ensure better product. You want people questioning the decisions that are being made, so that by justifying them, people have to think through what they're doing. They see the weaknesses. They have an opportunity to further refine what they're doing. Kind of like on an appellate court, where you have different perspectives that can weigh in, and there's a process that helps. But with the understanding that ultimately the president is the executive branch. All the power of the executive branch is delegated, and to the extent that you have some structure like that, it would be because the president saw value in it.
But what you're arguing is for good governance, good leadership. It's not a matter of law. I tell my staff, Ben Flowers, I think I saw him earlier today, maybe he went out to the bathroom, but my Solicitor General was here. He can vouchsafe what I'm about to say. I tell all my senior staff, about 25 people that work pretty closely with me, argue with me. I've got clay feet up to my hips. I've got blind spots 360 degrees, and they move around. Help me see what I don't see. Help me understand what I don't know. Help me be curious. Help me to learn. And we'll all have a better experience. Now, I don't abdicate my decision-making authority. I don't have a legal requirement to go out and hire Democrats to come into my Republican administration. But I do listen to other people. If we have a leader who's not inclined to have a diversity of input on a commission or a committee, that's a function of that leadership style. And the voters may or may not like it, depending on the outcome. But their remedy is at the ballot box. It's not to hamstring the leader that they sent to do the job of the people.
Okay, let's take some questions from the audience. Let's start with this microphone over here.
Great, thank you so much. Justin Smith, I'm a current law student at Scalia Law, and I had a question that sort of tackles this from a little bit of a different angle, if you will. So I'm curious, we saw in the last administration the enforcers use antitrust law to arguably extract non-economic rents in the form of DE&I and ESG. And if we were to see a return to that in the future, which I think is highly plausible, and if we saw a return with much more force, not to say that private actors aren't well funded and well equipped to fight these battles, but what role, if any, do the states have? And what, if there is a role, what does that toolkit look to push against that sort of federal power? Thank you.
Yeah. We did push against that federal power pretty effectively in a way that I think once you get the win on ESG and it's clear that it's not purely driven by driving the rate of return, but that it's incorporating policy preferences into what's supposed to be investment decision making, it's really hard to go back to that. So Tennessee sued BlackRock saying it was not antitrust, it was just pure consumer protection, saying you can't say both, we will maximize your return on investment and we will use every dollar of our assets under management to advance environmental causes. You got to pick one, and you're confusing consumers when you don't. But there's a great antitrust argument to be made. Literally, it sounds so conspiratorial, but literally, financial institutions controlling a tremendous percentage of the nation's and the world's wealth got together at Davos and decided we are going to make the world a better place by working together in an extraordinary collusive fashion. I mean, people who own not individual competitors in the industry, but own substantial pieces of entire industries were saying we're going to push the whole industry in this direction. Well, that stifles the competition that benefits consumers. And I think the more that we, through our investigations and litigation, were able to reinforce the idea that this was not based on business reasons, but was really based on policy decisions smuggled into the business operations, the harder it is for that to rear its head again. You know, they can't say we're not going to do it anymore and then come back and say it is essential for maximizing return for us to readopt these policies. So I think transparency has been key in righting the ship on that. And as a free country, if people knowingly want to invest in products that are oriented toward environmental or social or whatever goals, they're free to do so. But the big institutional actors can't steer every dollar in that direction without being transparent about it, without getting the consent of the actual owners.
Tools include the state's own investments. We saw a number of states very effectively refuse to participate in ESG or DEI-based investors. Also, litigation, the threat of litigation. I think the attorneys general collectively pushing back on BlackRock had a major impact on their reversal on the Net Zero Alliance. But the last thing I would say about that, I earlier talked about the private sector ability to gain government scale and power and action and reach. It's nowhere more apparent than in the financial industry with the Net Zero Alliance, where these massive supranational levels of capital are being pushed in a particular direction. That should bother everyone in this room, because that becomes more powerful than the elected government of this country. It outsources the democratic process and the lawmaking function from the people to the literally unelected and not even appointed actors who are merely wielding economic power. I think that's definitionally what Roosevelt was talking about, malefactors of great wealth.
So that's about the sort of concern about ESG in particular. On the general question of when antitrust enforcers reach a settlement and extract some concession from the regulated entity that goes beyond repairing the antitrust violation, is that something you worry about leverage exercised by the federal government, or is it something that you even worry about when you enforce the antitrust laws?
Yeah, I won't say I've never done it, but...
Yeah, I mean, we try really hard to avoid side prey and to push back when there's a collective effort in that direction. Our job is not to create policy by bludgeoning people into doing what we want. It's to ensure compliance with the law. And if what we're trying to extract is compliance, then that's great. That's our job. If we're trying to extract anything beyond that, the courts should be extremely skeptical of us using our leverage to obtain outcomes that are not mandated by whatever the governing law is.
Let's go to this microphone here.
Hello, I'm Chance Fletcher, and I'm very interested in the resource constraint problem with antitrust enforcement. I Googled your all's state budgets, both of your offices before this, and the budgets and sort of knowing quite a bit about how much it costs to litigate an antitrust case. There's like sort of a very interesting problem. I suspect that you can't do very many of them. And I'm wondering if there's interesting ways perhaps to solve that resource constraint problem by collaborating with potentially private antitrust enforcers or outside counsel or other potential solutions. So I assume you have a resource constraint problem. There's more antitrust problems than you can address. You probably like to address more of them. Are there ways to solve that in like by capital solutions?
Yeah, I'm nervous about key Tom. The notion of private actors standing in the shoes of government arose when the Crown had relatively few lawyers to enforce its interests, and the theory was we will incentivize private entities to do that. We're a long way from medieval England. We have, at the moment, plenty of lawyers, and with the advent of AI, it appears that we're going to have perhaps some additional lawyer capacity in the world. The challenge is the use, the delegation of the sovereign authority to a private actor necessarily creates the potential for abuse of power and conflicts of interest that are not easily mitigated or regulated. So I shy away from it. We've done it sometimes, and I think you have too, Jonathan, but it's not my favorite approach.
Yeah, we have to be really careful about that. We get pitched on ideas that people have, and every once in a while there's something where it's a clear problem, there's a clearly defined solution. We know exactly what the money we recover is going to be used for, and we will bring in outside counsel. For instance, in PFAS, we know we need money to pay for water filtration. The harm's clearly defined. We don't have the expertise in that. When we talked to outside counsel about it, it made sense to go with outside counsel. But it is a slippery slope, and we don't want to just be laundering the state's standing to enrich a bunch of contingency fee lawyers unless there's, in each case, a really good justification for it. I will further note, it's important to be careful about this because a number of AGs have been indicted over the last few decades for their contingency fee involvement, and the incentives are super dangerous there. So, I don't think it's a bug. I think it's a feature that we're resource constrained. I think it ensures that we pick the cases that are the most relevant, and that we really have to think through how we use that authority. And there are ways of supplementing it, but we have to be extraordinarily judicious in how we open the doors to those outside actors. And we need to make sure that the AGs are absolutely in control, that there are no conflicts. In terms of the broader contingency world, we saw all sorts of problems in, say, opioids, when you had people representing a bunch of political subdivisions, sometimes states, sometimes individual plaintiffs. Their interest was in maximizing the attorney's fees, not in actually looking out for the best interests of their clients. And that's not a personal failing. That is the institutional incentives. We are supposed to be incentivized in a better direction, and therefore we need to make sure that we do not become subservient to outside financial interests.
Thank you.
Let's go over here.
Hi, Matthew Bedell, second-year law student at the University of Akron. I have a question that's actually kind of following up in line with the previous two questions, which is a question of locality and a question of perhaps how this could be addressed for these expensive litigations. When You had discussed before about Ohio and Tennessee joining with other states in these massive litigation against these multinational corporations. Do you ever work in conjunction, tandem with the local U.S. attorneys in your states and perhaps bringing and effectuating change locally in the Sixth Circuit, focusing here, well, we're in Washington, D.C., but focusing in the Sixth Circuit specifically to get the change that you want in order to battle these big corporations who are forced to be here as a result of being pulled in by a federal court?
So as a former AUSA, I say this as charitably as possible. It's not meant to be a dig. The expertise to bring most antitrust cases just isn't there in the U.S. Attorney's offices. I mean, I'm sure SDNY has the capacity and some of the others do, but it is very resource and expertise intensive. Now, if you're talking about the ADM price fixing case where you've got like the guys in a room and the FBI is recording them on video saying, we're going to fix prices now, and then writing the prices on the whiteboard, like I could have done that one. But, for anything like more sophisticated than that, I think it's going to be really tricky for the locals to do it, especially given all the demands involving like violent crime and trafficking and some of the white collar crime that's much less resource intensive and perhaps much more impactful on the individual victims. So, I love the idea, but I think it's difficult to operationalize.
Okay.
You raised a number of issues: administrability by enforcers in courts, knowledge gap with econ, regulatory capture by large corporations, over-regulating companies, and then 51 different jurisdictions. I know Washington just started reviewing or asking for submissions for merger control. I think I have the state right there. Why not limit, with the wave of a wand, if you could, antitrust to injury and get rid of all prophylactic rules?
I mean, I think in part because businesses can benefit from the prophylactic rules. If there's a real problem that everybody sees coming, addressing it at the merger stage saves a lot of pain and a lot of inefficiencies down the road. I say that we don't have the new uniform merger legislation in Tennessee. We don't have the resources to really review mergers that much. Occasionally, the feds will consult us on something very local, and we'll take a look at it. But otherwise, at most, we're going to write an angry letter saying, boy, this looks like it might be a problem. Just a heads up, maybe we'll sue you, which doesn't do anything but promote uncertainty. So we generally try not to do that. I don't know if Ohio has a more robust merger review capacity.
We do not.
But I do think that, again, certainly streamlines things, and there are advantages to not doing that. But it's so painful to look for structural remedies after the fact. It should be reserved for the clearest violations. And if we have a pretty good idea that that's going to happen, much better to let the business move in a different direction early on rather than invest a lot in making moves that are going to be undone at tremendous expense and pain later on.
Well, there's an additional problem, which is that that process assumes that we in the government somehow have a crystal ball and know how the market's going to shake out. I remember the recent telecom merger, which ended up looking in practice very differently in 2025 than it did when it was predicted in 2021. The fact of the matter is we shouldn't have prior restraint mostly on business actions any more than we should on communication and speech. It is for the proponent of the problem to demonstrate and prove up that it created harm, not that it might. And I'm concerned that government is just not that smart, not that wise to be able to predict what a messy marketplace is going to create. And the last thing I would point out is that those letters and that kind of advance warning presumes that Tim Wu is right and that there is a curse to bigness. There clearly is not an inherent curse to bigness. Bigness creates scale. It creates economies of scale. It produces sometimes innovation and better prices and all kinds of good stuff. We should not assume that mere size is a bad thing.
We have the other microphone. Let's go there, and then I'll get
Hi. How do you handle it when counties within your state are simultaneously litigating in your cases with differing interests?
I didn't quite hear the answer.
The question is, what do we do when counties are litigating in cases that we're involved in?
Oh, why don't you take that one?
I mean, it's a real structural problem because we're both typically representing parents patriae, the same citizens, and opioids really clarified these issues, but it clarified the problems. It did not offer a lot of solutions. We don't see it as much in antitrust. I'm not aware offhand of antitrust litigation involving any Tennessee counties. We see it increasingly in consumer protection because it's a really easy vehicle for contingency fee lawyers. I mean, I get why they do it. It makes a lot of sense. And if you're a county and you're not a very sophisticated participant in complex litigation, and again, I don't want my county commissioner to be super up to speed on complex litigation. I want them to run the county well. But if they're given a pitch like, hey, free money, just sign up here, you'll get a bunch of money, we'll get a little money, but you're getting money you wouldn't get otherwise, so it's great for everybody. They don't understand the systemic impact of that. And often they don't understand that the money that we get is going to go to the same ends, resolving the same problems, except without the same big contingency fee. Texas had a great solution to it. They have legislation where the AG's office has to sign off on contingency representation of political subdivisions. That's a good way of ensuring that there's still an opportunity there for the political subdivisions in cases where maybe the AG's office isn't interested or doesn't have the resources, or where there's a really local concern where it makes sense to address it locally. But where you've got, the complexity of these massive multi-state cases is unfathomable. I mean, basically every legal commentator looking at it said opioids was the most complex litigation in American history. And to add more moving pieces as a result of the sovereign states having little pieces of them come in from a different direction makes it miserable, makes it harder to solve the problem. And often these are really important problems. And when we can't solve them quickly, there's a tremendous toll in terms of human suffering. So it's not really an antitrust problem from my perspective, but there is an issue there, and we need to be very thoughtful about how we approach that.
I would concur that it's not an antitrust problem. I will add one additional thing. While there's certainly room for local communities to respond to a local nuisance and bring in contingency counsel, I would argue that there must be almost like a standing analysis, a particularized injury that enables the local government to do that. So San Francisco could complain about its shoreline pollution against somebody who is a polluter. It could not bring a climate change suit because they don't have any differentiated harm. Here's the thing. Parents patriae descends from the sovereign. It is a harm on behalf of all the people. The states are sovereign. The cities and counties are creations of the state, and they have no individual sovereignty. As the Supreme Court cleverly put it, this is not the United Cities and Counties of America.
All right, why don't we take one last question from over here?
Okay, Chris Green from Ohio State. I'm curious about the prospects for reinvigorating an old doctrine of affected with a public interest. So Judge Oldham's opinion in the Net Choice case, the Fifth Circuit was kind of looking back to this tradition as a way to think about, the internet monopolists. ever since Nebbia in 1934, the Supreme Court hasn't taken it terribly seriously, but Charles Wolf, the 1923 case, theme that Attorney General Yost was saying, you need a heavy justification before you're going to have a government come in and intervene. You need some kind of market bottleneck. Nebbia limits federal 14th Amendment doctrine that way, but what are the prospects for the states going back to this? Munn versus Illinois is building on the states. It's a tradition that goes back to Chief Justice Hale from the 17th century. Why shouldn't we do that if you're looking for limits on state antitrust authority?
I think I need to read that Oldham opinion before having a good answer to that. But if Judge Oldham says it's important, it's important.
All right, I think that brings us to the end of our panel. I am supposed to tell you to join us in the International Ballroom Center, which is right next door, for the fireside chat with the Deputy Attorney General, Todd Blanche, at 2 p.m. Please join me in thanking our panelists.